ridicule, hostility, threats, and psychological distress, forcing him to temporarily leave his home in Kirinyaga County and seek refuge in Embu County out of fear for his safety. Mr. Maingi further contended that the Attorney General, AG, failed in his constitutional duty as the principal legal advisor to government by failing to advise His Excellency Gachagua appropriately regarding the provisions of sections 24, 25, and 26 of the National Security Intelligence Service Act relating to complaints against the NIS. The petitioner alleged violations of Articles 10, 27, 28, 29, and 47 of the Constitution, claiming that the impugned statements amounted to discrimination, infringement of human dignity, psychological torture, and unfair administrative conduct. Consequently, the petitioner sought the following reliefs: that there be a declaration that the constitutional rights of the applicant as provided for under Articles 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. B, that the first respondent be ordered to issue an apology to the NIS members and staff for the utterances and or speech made on the 26th of June 2024. C, cost of the petition, and D, any other relief the court may deem. The second petitioner did not, however, file any written submission. The third petitioner's case. Honorable Njeri Maina, the third petitioner in the consolidated petition, filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at Kerugoya. She is the current woman representative in the National Assembly for Kirinyaga County. She stated that she brought the petition on her own behalf and on behalf of the residents of Kirinyaga County, and in public discretion as and in public interest, her petition also principally challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings commenced against His Excellency Gachagua. She contended that public participation process undertaken by the National Assembly in relation to the impeachment motion was ineffective, inadequate, and constitutional owing to the short notice periods and inaccessible venues. She took issue with the insufficient dissemination of information, defective response templates, lack of proper facilitation of members of the public, and the alleged failure by Parliament to comply with court orders directing constituency-level public participation. She further asserted that the impeachment process violated Articles 10, 47, 48, 145, and 150 of the Constitution, and challenged the constitutionality of Standing Order number 64, 2 of the National Assembly Standing Orders on the basis that it imposed an unconstitutional 7-day timeline for disposal of impeachment proceedings, thereby undermining meaningful public participation. Honorable Maina also questioned the legality of the Senate's decision to conduct the impeachment proceedings in plenary instead of through a special committee under Article 145, Sub-Article 3B of the Constitution, urging that investigation of impeachment charges could only lawfully be undertaken by a select committee of the Senate. In addition, she challenged the legality of the National Assembly as constituted, contending that it failed to comply with the constitutional 2/3 gender principle under Articles 27, 81B, 100 and 261 of the Constitution, and was therefore incapable of lawfully entertaining an impeachment motion. As such, Honorable Maina sought for the following reliefs: A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th October 2024 regarding the special motion fell below the threshold of proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the modalities put in place by the first respondent in respect of the public participation forums held on 4th and 5th of October 2024, as ordered by this Honorable Court regarding the special motion, were in disregard of the court's orders and fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. C, a declaration that the impeachment process as against the first interested party undertaken by the first and the second respondents in their in view of modalities of public participation forums held on the 4th and 5th October 2024, failing well below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution, were unconstitutional and therefore void. D, a declaration that the appointment of a select committee by the Senate under Article 145(3)(b) of the Constitution is not discretionary in the impeachment of a president or deputy president in light of Article 259 of the Constitution. A declaration that any proceedings in regard to impeachment of the first interested party taken by the second and fourth petition respondents outside the select committee of Senate under Article 145 sub-article 3B of the Constitution are unconstitutional and void. F, a declaration that the first respondent is not legally constituted in light of the mandatory provisions of Article 2781B, 10261 of the Constitution on the 2/3 gender requirement. G, a declaration that the first respondent as currently constituted cannot entertain and deliberate the special motion for the removal of the first interested party by respondents. H, cost of the suit, and I, any other order or orders that this court may deem just. The third petitioner's submissions. Honorable Maina supplemented her positions by filing written submissions dated 9th of January 2026, and which she further orally highlighted in court. She identified the following issues for determination. 1, whether the public participation exercise conducted by the National Assembly on the 4th of October 2024 met the constitutional threshold under Article 118 of the Constitution. B, whether the yes-no templates deployed by the National Assembly violated constitutional requirements for meaningful public participation. 3, whether the Senate violated Article 118 by not conducting public participation at the Senate stage. 4, whether the Senate violated Article 145(3)(b) by failing to appoint a special committee of 11 members. 5, whether Standing Order 64(2) prescribing a 12-day impeachment timeline is constitutional. 6, whether the impeachment process violated Article 50 on fair hearing protections. And 7, whether the impeachment proceedings were conducted by impartial officers as required by Article 50, sub-article 1 of the Constitution. Honorable Maina submitted that on the 3rd of October 2024. Honorable Justice Mongo, a judge of the High Court sitting at Karibuya, ordered inter alia that public participation be undertaken at the constituency levels so as to accord the public an opportunity to engage and offer their representations. That these orders were duly served and were never appealed, stayed, varied or reviewed, and as such, they remain binding on the respondents, absolutely. Speaking to the obligation to obey court orders, Honorable Maina submitted that such obedience is foundational to the rule of law, as was held in Law Society of Kenya and 3 others versus Inspector General of Police, and 4 others reported in 2024 KEHC, KLR. She submitted that this obligation extended even to cases where the person affected by an order believes it to be irregular or void, as was held in Refrigeration and Kitchen Utensils Limited versus Gulab Chand, Popatlal Shah, and others, the civil application number Nairobi 1339 of 1990. She further submitted that proper compliance required reasonable notice and not the same day or the next day notice. Physical accessibility at constituency level with open, identifiable venues in each of the 290 constituencies, facilitation of engagement, including civic sensitization, information, language diversity, disability access, and hearings as the primary mode, including oral and interactive engagement. Learned Council further submitted that the orders were not obeyed and only 200,000 participants countrywide who made up to 0.4% of the Kenyan population turned up for the exercise. Council declared the one-day notice published on a Saturday, whose contents were vague as they referred to constituency offices without addresses and times. She also pointed out that no hearings were ever organized, no facilitation was provided, and that CDF offices were closed and the MPs absent. Honorable Maina submitted that she became aware of the purported exercise only past midday and that none of her counterparts within the Kirinyaga County were aware of the exercise. She further submitted that even the citizens who visited the constituency venues found them locked and no officials or staff were inside. It was submitted that the National Assembly faced a binary choice of obeying the Constitution through the court order or preserve Standing Order 64-2, which provided for 7 days deadline. They chose the latter, which Honorable Maina describes as contempt, dressed as obedience. That a legislative outcome obtained in defiance of a binding court order cannot stand in a constitutional democracy governed by the rule of law as discussed by Lord Denning in McFoy versus United States Company Limited, United Africa Company Limited, reported in 1961-3 All England Reports 1169, where the learned judge held that, I quote, if an act is void, then it is in law nullity. You cannot put something on it and expect it to stay there. It will collapse, end of quote. Honorable Maina also took issue with the yes and no template as constitutional fraud. The National Assembly deployed a standardized template reducing 7 complex constitutional allegations into binary tick box questions. That citizens were asked whether they supported impeachment on each ground without being supplied with evidentiary material, explanatory memoranda, and His Excellency Gachagua's response, relying on the Supreme Court in British American Tobacco BAT versus Cabinet Secretary for Health 2019, which we'll hear in after I'll be referring to as the BAT case. She articulated attributes of meaningful participation to include clarity of the subject matter for the public to understand, structures, processes that are clear and simple, opportunity for balanced influence from public, commitment to the process such that views can influence outcomes, and inclusive and effective representation. She also listed integrity and transparency of the process and capacity to engage on the part of public, including sensitization of the subject matter. Honorable Maina admitted that the digital-only, English-only mechanism systematically excluded rural residents, the elderly, persons with disabilities, the non-English speakers, and the non-English speakers. She stated that there were no physical venues for explaining the template or receiving oral views, that were only in 10, that there were only 10 pictures of people attached as evidence of attendance for the 5th October exercise, and that they were contained and that they were conflated responses from 4th and 5th October without distinction, obscuring the impact of the court's orders. She identified that the template was not a procedural imperfection, but an endorsement mechanism designed to manufacture numerical support for a predetermined outcome and is therefore constitutionally void. It was her further submission that Article 118 imposes an independent obligation on each House of Parliament to facilitate public participation in its own business, that the Senate is not a subordinate appendage of the National Assembly, as was held in Speaker of Senate versus Attorney General, reported in 2013, where she stated that the Senate's role in impeachment is determinative under Article 145(7), as it performs a quasi-judicial function of the highest constitutional order. She held the position that the Senate could not constitutionally rely on the National Assembly's defective process, particularly where that process was conducted in defiance of court orders, that the Senate was aware of these defects as they were documented, litigated, and judicially acknowledged. Counsel submitted further that in Mwangaza versus Speaker of the Senate 2025, reported in 2025 Kenya reports, this court held that Senate must satisfy itself that public participation was adequate and satisfaction requires inquiry, assessment, and independent judgment, but the Senate undertook none. That the Senate conducted no public participation whatsoever, as no notices were issued, no invitations were extended, no hearings were conducted, and no submissions were received, and that this is not a case of inadequate participation, but a case of none at all. It was also her submission that Article 145, Sub-Article 3b of the Constitution provides that the Senate may appoint a special committee comprising 11 members of its members to investigate the matter. On that, it submitted that the word may was a grant of power, not a license to bypass the Constitution, and that once the Senate had elected to proceed under Article 145, it must proceed within the architecture prescribed, which includes a special committee. Further stated that under Article 145, Sub-Article 6, it provides that the Senate jurisdiction to vote is triggered only if a special committee reports that allegations have been substantiated, and absent a committee report, the gateway to plenary determination was not opened. She also stated that the constitutional function of the special committee was structured investigation, not political debate, receiving, interrogating, and testing evidence, producing a reasoned report, and insulating investigation from the volatility of plenary politics. That Article 145, Sub-Article 5 of the Constitution, guaranteed the Deputy President the right to appear and be represented before the special committee, and by bypassing the committee, the Senate extinguished an entire constitutional hearing stage guaranteed to the Deputy President, thus violating the non-derogable right to a fair hearing. Learned Counsel submitted that standing orders confirmed this distinction as Standing Order 79 on the Deputy President impeachment provided for a special committee, but no alternative. That Standing Order 80 of the Governor's impeachment procedure impeachment expressly provides two alternatives, that is, a special committee or a plenary investigation. It was then posited that where the drafters intended to permit plenary investigation, they could have said so, and that the omission of the Deputy President must be respected.